Welcome to the MOOC on Consumer Protection Act 2019. We will begin the topic with the historical background of the consumer protection in India. In ancient India, people gave more importance to the human values, and based on that, a large number of trade regulations were enacted. Dharmasastras, which outlines the principles of how one person should interact with another, there also we found the traces of the consumer protections. Kautilya's Arthashastra, which was meant basically to deal with the administrative issues, there also we found certain traces of the consumer protection. In the medieval period, we can see that in order to give the consumer a proper protection, a number of weights and measures were introduced. Prices at that point of time was determined based on the local conditions. Coming to the British era, it was been found that the legal system of India has been overlapped with the advent of the English law. There we can witness that during the British period, a number of legislations were enacted, like the Indian Contract Act of 1872, the Sale of Goods Act of 1930, the Drugs and Cosmetics Act of 1940, so on and so forth. Since we didn't have any specific law dealing with the consumer protection, the Sale of Goods Act of 1930 plays the vital role for the protection of consumer at that point of time. Though there was no specific mention of how the consumer should be protected, but there are certain sections or certain provisions which provide certain protections to the consumers. Say, for example, Section 16 of the Act, which provides the remedy to the people or the person who has taken if the goods are found to be defective. So, for around more than 55 years, the Sale of Goods Act has played the vital role for the protection of the consumers in India. We know the principle of caveat emptor, that is, let the buyers be aware. But this enactment has got certain provisions which has been required to protect the rights of the consumers. But before entering into the paradigm shift of Sale of Goods Act to a specific Consumer Protection Act of 1986, we will be discussing the timeline, how this Consumer Protection Act of 1986 came into being. Now we will be discussing on the timeline how the Consumer Protection Act came into being. It all began in 1960, whereby the International Organization of Consumers Union was established by the Economic and Social Council. In 1977, this council was being granted with the consultative status, but even before that, in 1975, the International Organization of Consumers Union has persuaded the UN to draft a model code of consumer protection. In 1977, the Secretary General was being instructed by the Economic and Social Council to make a list of the consumer protection institutions and laws. In 1981, further it was being instructed to the Secretary General to continue with the consultation of the consumer protection and so that it can a general guideline for the consumer protection could be drafted taking into consideration of the situation or the conditions of the developing country. In 1982, a draft guideline was being submitted and it was forwarded to all the countries for the recommendations or suggestions. In 1983, incorporating the suggestions and recommendation, it was submitted in Economic and Social Council, and in 1985, it was the UN Assembly has unanimously adopted the United Nations guidelines for consumer protection. And following these guidelines, India was one among the few countries who has enacted a law, a specific law for the protection of the consumers, that is the Consumer Protection Act of 1986. Objectives of the Consumer Protection Act 1986. The Consumer Protection Act was enacted keeping in view of certain objective, and as we have already discussed that it was based on the UN guidelines on the consumer protection. So the basic objective of this enactment was to provide the better protection to the consumers. That is, the interest of the consumers were given the priority in this particular enactment. But how a better protection can be provided? And for providing the better protection, the quasi-judicial mechanism was introduced. Quasi-judicial mechanism, what is it? Quasi-judicial mechanism means if any right of the consumer is being infringed, then the aggrieved consumer, in place of going to the court, which takes a long time and it's a lengthy procedure which most of the layman or most of the general person avoid to go, and that's why that might be one of the reason that the consumers were reluctant to go for any kind of benefit or remedy. So in order to give it more consumer friendly, a quasi-judicial mechanism was introduced, and this mechanism had the 3-tier system, that is in the district level, in the state level and in the national level. Depending on the amount which is at stake or the amount of the case or the suit, it could be instituted in the different forums. Then the another purpose of this enactment is to protect the rights of the consumers. Like the protection we have been given to the consumer for against the marketing of goods and services which are hazardous to life and property of the consumer, or they have the right to be informed of the quality, quantity, potency, purity, standard and price of the goods. They were being given a protection against the unfair trade practices. They had a right to go for an redressal, seek redressal under the Consumer Council, or the mechanisms provide for giving the redressals in the Consumer Councils, in the district, state or national level, against the unfair trade practices, against the restrictive trade practices, and also there was the provision that the consumer should have a right to get aware of their rights. So these were the basic objective of the consumer protection, followed by the Consumer Protection Councils, which has their own objective that they can provide the remedy in all levels and very easy way. Now this quasi-judicial mechanism of providing the redressal has enabled the consumer to get a speedy recourse for the consumer disputes. So these were the few objectives of the Consumer Protection Act which we had discussed. But now when we come back to the Consumer Protection Act of 1986, now we are talking about 2019 Consumer Protection Act. Then why, if it is providing us with so much of facilities, why do we require to have a new act? This is the question. Now the question could be solved with an answer that with the changing society, we require to make certain changes in the enactment. Now the next question comes, then it could be done through the amendment. Yes, it had been done. There are three major amendments in the Consumer Protection Act of 1986. One of them is in 2002, which has actually made enormous changes in the consumer protection. But there are certain basic changes which has came into force, which was not even been anticipated at the time of enactment of Consumer Protection Act of 1986. At that point of time, people could not even think of that they will be sitting at home and doing the transactions or purchasing the commodities just from the convenience of their home. They need not to go to the market. Just recall those days when our parents or grandparents used to go to the market. They used to go and procure the goods from the shops. They preferred to go and procure the goods from the shop having a proper reputation, or whom they know that they deal very fairly. But when you are doing an online transaction, you are making an e-commerce, you are taking an help of an e-commerce, you are making an online order of a good, we don't know to whom we are transacting with. So to enable or incorporate these provisions or the technologies, we require to have enormous changes, and it could not be possible to make changes in all the provisions of the law. So that was the reason that we required to have some vital or major changes with a new enactment. So in order to incorporate these changes, in 2011, a bill was put forward with certain suggestions specifically on the unfair terms in contract, because it was one of the major things which was lacking in 1986 Act. If there is any unfair terms in a contract between a consumer and the merchant, there was no method to get a remedy out of it. So it was being introduced in Bill of 2011. But it was lapsed, and in 2015 a new bill was introduced with additional clauses along with this unfair term in contract. There were other provisos which were being added. One of the major was about the product liability and establishment of the regulatory authority. But again, and this particular bill was being forwarded to the Standing Committee of Consumer Affairs. And this Standing Committee of Consumer Affairs has submitted the report in 2016, making certain recommendation and even providing penalties for the misleading advertisement as well as to the endorser of such advertisements. But this this could not be passed. In 2018, again this bill has been presented but could not be passed. But again in 2019, finally this bill was being introduced and passed, and we got the Consumer Protection Act of 2019. Now let's discuss what are the objectives of Consumer Protection Act of 2019. The major purpose of Consumer Protection Act was to give protection of the people from the hazardous goods. Now, with the introduction of the product liability concept, now it is not limited only to the extent of if a product is being found to be defective or compensation was being given in 1986 Act. But here, if due to the product any injury is being sustained in the body or property of the person, that is also need to be compensated. So the basic purpose was to provide the safeguard to the body or person or the property of the person. And this was followed by certain other objectives like the right of data. Now the purchaser has the right to get the information of the quality, quantity, potency, strength, value, contents, all the things, all the ingredients which a consumer is supposed to know. That might be the reason you might have witnessed that if you are buying an electronic gadget and it is saying that it has a 5-star rating, that means it will consume less electricity. There you will find there is a badge or a tagline being given whereby the details of the things of the energy consumption and everything is been mentioned. If you buy a food item, you will find that there the label contains the ingredients of the food items and that too in what composition. So these are the provisions these have been made to be done in order to enable a consumer to aware of these things. The further there are other things like in order to protect a consumer from the monopoly of the businessman, or rather we can say that in order to provide a consumer with an option of getting a large variety of products in a competitive price is one of the objective of Act of 2019. Apart from that, there are appropriate forums which we also had in Consumer Protection Act of 1986, but now the pecuniary jurisdiction has been changed. It has been changed from and it has been elaborated. In the previous time when it was the district forum, they had the pecuniary jurisdiction of dealing with the cases of the valuation up to 20 lakhs. Now they have the more elaborate jurisdiction that they can hear the cases up to 1 crore. And that is happened with the state jurisdiction as well as the jurisdiction of the National Commission. Apart from that, the other objectives of the Consumer Protection Act of 2019 was to provide a protection against the unfair trade practices, restrictive trade practices and unethical exploitation of the consumers. And consumers' right to aware, right to have the information about their rights is also there in 2019 Act. Now, in this way, we can say that 2019 Act is an advanced version of Consumer Protection Act of 1986. There are few things which has been incorporated as which was been updated in 2019 Act. Say for example, the definition of the consumer. The definition of the consumer was there in 1986 Act as well as in 2019 Act. But what the difference it has been that it has an addition in the form of the clause in the explanation part, whereby it has been said that if a person is buying a product from any source, may it be an offline market and it has or an online market. So it has incorporated the products which are being purchased from the online shopping or from the multi-level marketing or the direct selling. So it has elaborated the scope of the consumer to get the protection. There were certain other things which were not been discussed, which were not been defined at all. Say for example, if we talk about the consumerism, or if we talk about the rights of the consumer, this term, the right of the consumer, was not at all been provided in 1986 Act, though certain rights were being given in the form of Section 6, Section 7 or 8b while dealing with the objectives of the central, state or the district redressal forum. Or but in 2019 Act, what we see that Section 2 of Section 2 Clause 9 of Consumer Protection Act of 2019 defines the consumer rights, and it provides the 6 rights for a consumer, which is an expressly been provided. It says that the consumer has the right to be protected against the marketing of the goods or the products or services which are hazardous to the life or property. They have right to be informed about the quality or quantity or purity, standard and the price of the goods, products or services as the case may be, so that they can be protected from the unfair trade practices. They have right to be assured wherever possible to access a variety of goods, products or services at competitive prices. The right to be heard and to be assured that consumers' interest will receive due consideration at appropriate fora. They too have a right to seek redressal against unfair trade practice or restrictive trade practice or unethical exploitation of consumers, and also have the right of awareness. There are certain other elements, as I was already saying about it. There are certain other elements which were in the definition clauses or which were being incorporated in the 2019 Act, which was not been there because the basic purpose was the technological advancement and the changes brought by the technological advancements. Some new and important additions which are required to be defined or which are referred to define are the term e-commerce. It has been defined, means buying or selling goods it includes the digital products over digital or electronic network. Then we have the definition of the electronic service provider. We have the definition of the misleading advertisement. Before going to the misleading advertisement, I will just like to clear one point that prior to this, there was no concept of providing or penalizing the endorser, that is the person who is working on the advertisement. So the endorsement is required to understand before understanding the misleading advertisement. Endorsement in relation to advertisement means any message, verbal statement, demonstration, depiction of name, signature or any identifiable personal characteristic of an individual or organization or any institution which makes the consumer to believe that it reflects the opinion, finding on experience of the person making such endorsement will be considered as an endorsement being done by such person. Now, why do we require to understand the endorsement? Because in the misleading advertisement, not only the person who is advertising, that is the owner of the concern or the business or the manufacturer, but even the person who is endorsing it in the advertisement, both can be subject of penalty. Misleading advertisement. When we talk about the misleading advertisement, it was not defined specifically in 1986 Act. It was not actually directly addressed under the Act, but there was, when defining the unfair trade practices, there was a expression, misleading representation was being mentioned. And under the proviso of section 14, which describes the power of the district forum, there was a clause regarding that if there is a such kind of misleading advertisement, then that advertisement need to be gone for a correction and to neutralize the effect of the misleading advertisement, and the cost of such correction of the advertisement is to be borne by the advertiser. But there was no penal provision, no provision of the penalty was being given in 1986 Act. But when we come to the 2019 Act, it has not only specifically defines the term misleading advertisement, that what amounts to misleading advertisement under section 2 clause 28, which includes the false description of a product or service, some fabrication which likely to mislead the consumer, to convey or express or implied representation, or to deliberately conceal some important information. Now, in 1986, since the court was not empowered to give any penalty, but the court has the power to issue orders leading to discontinuance of such advertisement. And they can order to make and release corrective advertisement. Whereas in Consumer Protection Act of 2019, Section 21 directly defines the widened power of central authority to issue directions and penalties against the false or leading advertisements. Now, in order to understand that what is a misleading advertisement and what are the penalties for the first offense, if an offense has been committed by the manufacturer or endorser, that is, which amounts to a misleading advertisement, they can be subject to a penalty which may extend to 10 lakh rupees, and for the subsequent offense it may extend to 50 lakh. Furthermore, if it is an endorser who is endorsing such kind of misleading advertisement, they could be barred for doing any such endorsement for a period of which may extend to 1 year, and for the subsequent offences or subsequent act of these kind, he could be barred or she could be barred for an extent of 3 years. Now, what this misleading advertisement is, to make it clear, I'm not going to the exact name of the case. We all are aware of the name of the case of the name of Horlicks and Complan. So there was an advertisement given whereby it has been shown that a cup of Complan is equivalent to the 2 glasses of Horlicks. Now, obviously, the Horlicks Limited has contended and has reached the court and has asked for the permanent injunction. Though there was a disclaimer given by the advertisers, that is the Complan, that is Zydus Wellness Products Limited, that this was based on certain information being given, and that 2 cups of Horlicks will equal to 1 cup of Complan. But the court held that this amounts to a misleading advertisement. Similar is the case which we have recently noticed during the pandemic, whereby we all know about the Dettol. We know about another product, that is the Lifebuoy. So Dettol was giving an advertisement whereby it has been said that the soap in the cake nature is not sufficient to protect us from the viruses. It is only the Dettol hand wash which can protect us. It was again being contended by the company, that is the Hindustan Unilever Limited, for whose product is the Lifebuoy, and it was being found that this is a misleading commercial and misleading advertisement, and it has to be immediately it was being stopped from the telecasting. Now, when we come to the advertisement, there are certain times when we have the comparative advertisement, but It is allowed to make a comparative advertisement to the extent a company is saying or company is guarantees his benefits, but it should not extend to the demeaning the other competitor. Now, we have already discussed about the redressal forum. Now, this is the basic difference between the two. In the district forum, the pecuniary jurisdiction was up to 20 lakh. Now, in the district commission, the district consumer dispute redressal forum, this terminology has been changed in 2019 Act. Now it is known as District Consumer Redressal Commission. And the state commission, the power was of 20 lakh to 1 crore. Now it has been extended from 1 crore to 10 crore. And for the national commission, it was above 1 crore, which was been the subject of the national commission. Now the national commission has a pecuniary jurisdiction above 10 crores. And this is the structure of the redressal forum under the Consumer Protection Act of 2019, whereby the district forum is at the lowest, then followed by the state commission, national commission, and at the end we have the Supreme Court. Now, another major changes which has been incorporated with this is the establishment of a regulatory authority which is named as Central Consumer Protection Authority. And they have been entrusted with certain responsibilities, that is to execute inquiries into the infringement of the consumer rights and initiate lawsuits. They can initiate it suo moto, or they can initiate with under application of the consumer. They can order for the recall of dangerous, hazardous, unsafe products and services. They can order for suspension of unethical commercial practices and the false advertisements. They can impose fines on suppliers or endorsers or publisher of false advertising. So these are the power being entrusted to the Central Consumer Protection Authority, and they have also the power to impose fine, which ranges from the 100K to 5 million. And they also have empowerment to provide or sentence up to provide a imprisonment up to life, that is a life imprisonment penalty could be provided by the Central Consumer Protection Authority, which is totally new in its forum. And this is being given in the cases when any product or service is hazardous to the life or property of the person, depending on the case to case basis. Apart from that, into the 2019 Act, there are some additional mechanisms being added. Like one of the major one is mediation. In 1986, there was no concept of mediation, and to 2019, we got that the dispute settlement could also be done by the mediation in case of compromise at the acceptance point of the complaint or some future date on the mutual consent. And a mediation cell would operate in each city, state, or national commission and regional bench to expedite the redress. So this method, we can say that mediation was being incorporated to expedite the redressal process, because one of the major lacunas which we have faced in 1986 Act was lacuna was that whatever the cases, though the cases, the disposal percentage of the disposal of the cases was very high, but the time taken for such disposal was too long. So in order to expedite these process, this one additional mechanism has been added in 2019 Act. Section 74 to Section 81 of the Act lays down the detailed procedure of the mediation. And also it has provided, because in any other redressal forum, if you are not satisfied with the decision of the redressal forum, we always have an option of go for the appeal. But for the mediation, since the dispute settlement is mostly happen in the cases of the compromises, that's why, or acceptance at the point of the by the complainant, and the compromise by the part of the complainant and the offender. offender or the wrongdoer. That's why it has been provided that in mediation there is no appeal lies against the order passed by the mediation. And the last thing which we will be saying, that the Consumer Protection E-commerce rules of 2020 has been incorporated or notified under the Consumer Protection Act on July 23rd, 2020. It is aimed to prevent unfair trade practices and protect consumer interest and rights in e-commerce. Thus, the Consumer Protection Act of 2019 has brought the major changes in the consumer protection paradigm in India. We can say now the consumer has been given more enormous right. They are being given more methods of having a remedy, or more methods of getting or seeking redressal in the forums, in the different forums. Thank you.